Okay, I'm putting this video out because I feel like, not feel like, but I'm strongly like can see that this crown, Tim Olorenshaw, and I'm gonna put up his picture. Tim Olorenshaw from 10 Armory Street. This crown is blatantly infringing on my rights right now. And when I say that, I'm gonna I'm gonna play you what he said in court today because I sent him some documents. They're trying to say I didn't complete a court order. I completed the court order. I was in court in front of a judge that acknowledged that I completed the court order. And the judge told me that I completed the court order. I didn't have to come back to court. A couple weeks later, Barbara Scully, there's another video of her with a bunch of police blocking me in a room on the channel. She comes, tosses a paper at me, says I have to go to court. Now, I didn't touch the paper or nothing. My probation officer, because that's where I was at the time, took out the paper and read it to me, saying that I failed and I breached the court order. I'm like, wait, how did I breach the court order? How did I fail to complete the order? They're saying that it was 48 hours I had to complete the order. Mind you, when I got arrested, there was a blood test taken same day, same night, under police supervision. Okay? This is before even any court order was given. Okay? They said it wasn't sufficient blood. And because I know how these police are, I said, listen, I don't want you guys in contact directly with my DNA or my blood in any way, shape, or form because I don't want to find my DNA on no crime scene in anywhere in the GTA or in Canada for that matter. When they gave me the letter, I told them I had to speak with a lawyer and I'll basically follow the directions of the lawyer. Speaking with a lawyer, it took me some time to get to the lawyer, but I got to a lawyer, paid my money, got the consultation. The lawyer advised me, listen, do the blood test, and if you're worried about them doing anything shady with your blood, go way out of town and do it, which is exactly what I did. Again, before the deadline. Now, this morning I sent Tim Olorenshaw because, in my knowledge, this is pointless. Because if I did the blood test, why are you trying to charge me for something I didn't do? And then you're trying to say I had 48 hours, but you took 2 vials of blood. They took 2 vials of blood at the hospital. And then on the second time after the court order, I gave 5 vials of blood. So, and they all came back clean. So I don't understand how Tim Olorenshaw now, I sent him proof recording, not just the judge Shindoy saying I completed the order, but also Philip Norton, who is the lawyer representing the officer, saying he received these. And I'm expressing to him that to carry this on any further and to continue trying to bring this to a trial where you have to prosecute me is going to lead to bigger issues. And he's basically saying that he basically told me, I'm going to, like I said, and I'm also going to play today what happened in court so you can hear him saying that he was at my last hearing that has nothing to do with these charges. Not only was he at the last hearing, he's waiting to see the results of those cases or allegations before he makes a decision. And I find that to be highly biased. So I'm making this video for any lawyer out there, any lawyer, any law, anyone that's has law under their belt, like not civil law, criminal law under their belt, because I I need some second and third opinions on this because I haven't had a chance to go over the crown duties yet in regards to this specific thing, but I just feel like there's some sort of liability here. I just feel like there's some sort of liability here. The fact that him coming to my court date, him saying he's not going to move the charges forward, even though there's evidence proving that I did whatever I finished the order that the court ordered me to do in a timely manner, in full. And they're saying I didn't do it. I have proof of this. So I feel like this guy is trying to deprive me of my rights, and I need, like I said, I need help on this, and I'm not the type of person to ask for no type of aid or help in any way, shape, or form. I do things on my own. I find my way to get things done. But this is this is dragging out way too long.
Thank you. Thank you. So, Your Worship, these are unusual charges before the POA court. It is under the mandatory blood testing act. They're related to some criminal matters that Mr. Brooks has before the courts. I was in attendance at his judicial pretrial just last week on the 17th, and the matter was set down for trial. So what I'm going to suggest is if Mr. Brooks wants to ask the court to adjourn these matters to see how the criminal matters proceed, I'm certainly not opposed to that. His next criminal trial date is August. You let the court know how you wish to proceed.
I sent an email with the last appearance with the judge Chindoy, who acknowledged that I had completed the blood test and informed me that I didn't have to reappear on the matter. So I was surprised to see I got a summons to court. And I also sent you a phone call between me and Mr. Norton where he indicates that he did get them. So I'm not sure where the misunderstanding is, but it's not on me. I did them before the deadline that was given to me. And even on arrest, there was also blood drawn on arrest too. But in regards to the court order, I filled them and I sent in you can also contact Ms. Shindoy and Philip Norton to confirm this too.
Okay, Your Worship, I'm going to suggest this. I'm not in receipt of any of this documentation. I wasn't present for the matters before Her Honor Shindoy. If Mr. Brooks has some documentation with respect to the blood testing, medical documentation, if it's evidence, you may just want to hold on to that, wait for the criminal proceedings to go forward, because the charges before this court are separate, and my concern is you don't want to do anything that would prejudice yourself.
If this was an order that I filled, how does this affect the other charges?
Well, it doesn't actually, Your Worship, because the charges before this court are a result of an order made by the Consent and Capacity Board. An officer had made an application to have a blood sample taken from Mr. Brooks, and what is alleged is that he didn't adhere to that order within the 48-hour time frame. So my understanding is Mr. Brooks is contesting that. So that these charges would proceed regardless of what happens on the criminal side, because it's basically what's alleged is a breach of a court order, a breach of an order made by the Consent Capacity Board. So Mr. Brooks is right. The two, in a way, aren't related. They can proceed separately. From the prosecution position, if there was some kind of global resolution in play, that's certainly something we could bring all the charges together, but it's my understanding that Mr. Brooks is not interested in a resolution on the criminal side. I will let him confirm that for the court. He did set a trial date at his last judicial pretrial on the criminal side.
The blood test, I had two separate instances where I had blood tests. One before the court order, the same day when I was arrested under police supervision, and then one after the court order. So I don't understand. Even if it was within the 48 hours, I still had blood tests drawn within that 48 hours.
And again, if Mr. Brooks is asking for adjournment, I'm certainly not opposed.
The reason why I'm asking.
The conversation.
Sorry. No, I didn't want to cut you off. Sorry.
No, go ahead.
Second, before you continue, I agree. So your matter is not before this court for trial today.
No.
It's to be spoken to.
I'm not getting into details. I was just letting you know.
Yeah. No, I appreciate that. It's bestly speaking. I think at this stage we have to decide what do you wish set your matter down for trial at a later time. Since your other matter is set for trial between the August 12th and 14th, you wouldn't get an earlier trial date than that. But whatever, it's not going to be resolved here today. This is just an update for it, if you will.
Yeah, I understand. I understand that the Crown is the one ahead that decides ultimately who, if it's going to court or not, and this is why I sent these information so he could possibly contact Judge Shindoy and Philip Norton so we could go to a resolution instead of looking for trial, because I did finish this and it would.
Are you the assigned prosecutor, Mr. Olorenshaw?
For these POA matters, but the documents that Mr. Brooks is referring to, I haven't seen any of that. So that's why I invite him to, first of all, seek legal representation. And then if there's something he wants to share with my office that might lead towards resolution of these charges, then that's great, fantastic. But I do strongly encourage him to get some legal representation.
And had a couple consultation, and they advised me that it's a matter where I could speak to the Crown and seek resolution instead of going forward with a possible trial on top of me already having to deal with another set of matters, and especially when there's evidence that I finished it. So this is why I sent you the email to the email that's on the screen here.
Are you self-represented on the criminal trial matters?
At the moment, but now I'm gonna play the Shindoy recording. I'm trying not to make the video too long, so bear with me.
Office. I received confirmation that Dr. Forrester has ordered the blood sample. I have received the consent signed by Mr. Brooks and Dr. Forrester to provide me with the limited medical information that would be derived from the blood sample from November 20th.
Norton. Mr. Brooks, would you like to update the court on? Thank you so much also for your cooperation.
Are you asking me? Hello?
Hello, Mr. Brooks.
Yeah, I think there's some Wi-Fi trouble.
Thank you. Well, thank you for your cooperation. Mr. Norton has updated the court that you saw Dr. Forrester and you provided the signed consent, so thank you very much. Mr. Norton had a question for you. He was wondering whether you had provided the blood sample to Dr. Mr. Norton and Mr. Brooks. We're now finished with this matter, so I'm going to conclude. Mr. Norton, did you have? So, Mr. Norton, you can ask for another case conference if you don't have the results in a week. It might take a little bit longer, but we have Mr. Brooks's word that he did attend the life labs and he did provide the samples, and so you can follow up with Dr. Who would have made the blood requisition, and he would have gotten a copy of the test results. So that's what I suggest to you. So I'm just going to finish and say that Mr. Norton, you can follow up with Dr. If you need further assistance from the court, you can contact my office. Mr. Brooks has completed all the steps that he's required to do, so we're going to conclude today. So thank you both for appearing. Mr. Brooks, we're now concluded, so I want to thank you so much both for your time, and this concludes the matter. Thank you.
Hello?
Hi, good afternoon. May I please speak to Mr. Norton?
Speaking.
Mr. Norton, this is Brooks speaking. Have you not gotten the results of the blood test?
I have.
So
You just listen to me, sir. I've received the information from your doctor. Your doctor will have proof that the fax was sent to me. And so that's your proof that I received it.